Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast 66. In this podcast we're going to be discussing three different cases. The first one considers contractual flexibility in an employee's contract and whether or not the employer was justified in imposing a unilateral change to her working hours under a contractual variation clause. Secondly, we're looking at whether an employee sending pornographic emails from his work account constituted a repudiatory breach of contract, entitling the employer to dismiss him summarily. Key consideration of the High Court in this case was that the discovery was only made by the employer several years after the email was sent out. Not only that, but the email was discovered as a result of a phishing exercise carried out by the employer seeking to find a reason to dismiss summarily. Thirdly, we have a case which considers the use of an e-cigarette on work premises and a constructive dismissal claim associated with that process. Finally, as a reward and a recommendation, I'm going to have a podcast recommendation at the end of this podcast. I have in the past recommended podcasts. Most recently I recommended the podcast series Serial, and that got a number of quite favourable comments back from podcast listeners, so I thought I'd come up with another recommendation podcast series that I've thoroughly enjoyed. So, business first, of course. So the first case is Hart and St Mary's School, Colchester Limited, and this is an EAT decision concerning unilateral changes to an employee's contract of employment, and highlights the importance of clear and unambiguous drafting, where a need for flexibility around working hours and patterns is required by the employer. A quick summary of the law in this area might just help. Changes to an employee's terms and conditions, well, that generally requires mutual agreement. Where an employer intends to rely on a right of unilateral variation to an employee's contract given by the contract itself, the contractual variation clause must be stated in clear and unambiguous terms. Equally, the employer is required to provide warning of the change to the employee or employees and to consult, discuss the potential changes. It's not uncommon for employers to include a unilateral variation clause in their employment contracts, but we've seen previously employment tribunals can be reluctant to enforce such clauses. So, for example, in the earlier case of Bateman and Asda Stores Limited, the EAT upheld the tribunal's decision that a provision within Asda's staff handbook was a variation clause that had been incorporated into the contracts of employment, and on that case, the staff handbook did permit Asda to make changes to the employee's work and pay regimes without employee consent. It was a really unusual case, and given the trend of decisions before and after it, which highlight the difficulties in exercising unilateral variation clauses when making changes to employees' T's and C's. However, in the Bateman case, the EAT and the tribunal were both very clear that an employer's right to vary unilaterally an employee's terms and conditions requires, first of all, the variation clause is clear and unambiguous. Secondly, the employer has to comply with the variation clause itself. Thirdly, the employer mustn't act arbitrarily or capriciously, and the implied duties of mutual trust and confidence must also not be breached as a result of any changes made or the way the changes are put into practice. The case also highlighted the need to satisfy other requirements, such as warning the employees of these changes and the need for a detailed process of consultation. Although, as I say, the employer was successful in Bateman, the EAT's decision highlighted making a lawful but unilateral change is no mean feat. Well, in this case, the Hart and St Mary's School case, the key facts were that the school decided to change Ms. Hart's working hours to fit with the school's proposed timetable changes. At this point, she was working as a part-time learning support teacher for 3 days a week. The school proposed to change her working hours to be spread over the full working week. However, consultation on the changes with her failed. She was unable to work Fridays because of other family commitments. When no agreement on the variation to her hours could be reached, the school decided to impose the changes unilaterally, relying on the variation clause in her contract. She then resigned. She claimed constructive dismissal. Now, there were two key clauses in the contract of employment. Clause 2.1 said, during school term time, except as may be provided for under clause 1.4, the teacher shall work all school hours while the school is in session, and at any other time as may be necessary in the reasonable opinion of the principal for the proper performance of his/her duties. Now, that clause refers to clause 1.4. Clause 1.4 says, in the case of a teacher on a part-time contract, the fractional part will be notified separately and may be subject to variation depending on the requirements of the school timetable. So, two clauses, both of which refer to variation, one of which specifically talks about part-time employees, the individual as a part-time employee. Without knowing the answers, please vote no. Vote now. How many people think that clause allowed the school to change her hours unilaterally after a proper consultation process? Well, the Employment Tribunal, I should say, found the school had been entitled to impose the unilateral change to Ms. Hart's terms and conditions. The tribunal felt her hours were not fixed. They said the fact the school had consulted with Ms. Hart in good time formed part of their decision, and they said that she had been given enough time to put forward proposals of her own, but had chosen not to do so. Reliance was placed on the fact that the contract provided for flexibility in Ms. Hart's hours, as she was required to work the hours considered, quote, necessary in the reasonable opinion of the principal, unquote. And there was a separate dispute as to whether she'd resigned in response to the alleged breach, but I'm going to focus on the issue of variation only. Well, having lost the case, she appealed to the EAT on the construction of her contract, and she argued that had been misinterpreted. And the EAT concluded that Ms. Hart's employment contract did not provide a complete record of her terms and conditions of employment, and they felt that the extent of her part-time working was either agreed in some other document or agreed orally. It was an important part of the factual matrix put forward to the EAT that when the contract was entered into, it was already a part-time contract, and that, I think, coloured their judgment. The EAT dismissed the school's argument that Ms. Hart's hours were not fixed, but gave extensive consideration then to the variation clause. First of all, the court decided that clause 2.1 did not apply. The reference to flexibility in clause 2.1 and working such hours as are necessary in the reasonable opinion of the principal, well, that flexibility related to work outside the school hours. Since this was a variation that related to work within the school hours, clause 2.1 didn't apply. Instead, this situation was governed solely, if at all, according to the AT, exclusively by clause 1.4. And if you remember, this said, the fractional part, quote, may be subject to variation depending on the requirements of the school timetable, unquote. The fractional part being the way they referred to the fact that individuals who are working less than full-time are working a fraction of a full-time. So the fractional part may be subject to variation depending on the requirements of the school timetable. Well, that's clear, isn't it? Well, no, it's not, according to the AT. The AT held that the wording of this clause was permissive. It may be subject to variation. It didn't set out in what circumstances the variation would necessarily take effect. The EAT's decision focused on the ambiguity surrounding who could request a variation. Although the EAT identified the variation was more likely to take place at the behest of the school, it didn't regard the wording as making that entirely unilateral. Instead, the EAT concluded that the changes could also be at the request of Miss Hart. Miss Hart might be wanting to vary her contracts, quote, depending upon the requirements of the school timetable, unquote. Although the EAT determined the variation would have to be subject to the requirements of the school timetable, ultimately the EAT felt that the drafting of the clause permitted the school to refuse Ms. Hart's request for a variation, and therefore the opposite applied. So in other words, if Ms. Hart didn't have a unilateral right to amend her hours upon the requirements of the school timetable, but the school could refuse consent to her request to change, then the same applied if the school wanted to change her hours because of the requirements of the school timetable. Even though the changes to the school timetable phraseology here might suggest that there should be a variation unilaterally, the EAT concluded this did not give the employer the right to vary unilaterally. Consequently, the EAT overturned the tribunal's decision, concluded that the unilateral variation clause in this case was neither sufficiently clear nor unambiguous, for the employer to implement the changes unilaterally. Perhaps had the facts been slightly different, in my opinion, the drafting of the variation clause perhaps tighter and given the school an express absolute right to vary her hours, there would have been a different outcome here. I say this in particular because the school had clearly gone through a process of communication, information, consultation in her case. And these are all key factors in the successful reliance on the variation clause in the Bateman case. I don't think the case establishes any major new principle of law. So why did I want to discuss the case? Well, we see a lot of cases where employers are looking to change terms and conditions of employment. And there's often a variation clause in the contract, which on the face of it might allow the variation to be made unilaterally by the employer. The employer will in most cases want to try and agree the variation with the employee. There are relatively few employers that will go ahead unilaterally without warning. However, if the employee refuses, I think this case illustrates how difficult it can be to get the court to accept the validity of a variation clause. There is in principle no reason whatsoever why a variation clause cannot work, but this case illustrates just how hard the court is prepared to work to find the clause does not permit a unilateral variation. In this case, the relevant part of the clause said that in the case of a teacher on a part-time contract, the fractional part will be notified separately and may be subject to variation depending on the requirements of the school timetable. I think it's probably fair to say the natural reading of this is that it's the school that will vary the hours depending on the requirements of the school timetable. It is surely not the natural construction to say that it is the teacher who may vary the clause depending on the requirements of the school timetable. However, here, because the contract was arguably, and in my view, only slightly unclear, the court felt able to say that either party could vary, and therefore, if either party could vary, it was obviously going to be subject to consent if she was seeking to vary, therefore she had the right to refuse it if the school wanted her to vary. So I think the clear message is that if you're drafting variation clauses, you need to assume that if you leave a loophole, the court will exploit it to defeat the right to vary unilaterally. But with careful drafting, you may be able to increase the chances of the unilateral clause being upheld. Now, this is very relevant when an employer has, right at the start of a process, it has to make a choice as to how to introduce the change. On the one hand, an employer can assert reliance on a variation clause in the hope that the employees will not seek to challenge the clause, or that the clause is sufficiently tightly drafted that a hostile court can't find its way around it. On the other hand, an employer who is looking to introduce changes may have to accept that it has to go through the dismissal and re-engagement route. Employers never like doing that, I would add. But it is a well-trodden path, and as a very, very broad generalisation, the courts have shown themselves relatively accepting of an employer's business rationale for introducing the changes, and so they scrutinise the process adopted before the decision is implemented. That tends to be the primary focus. Ironically, therefore, the courts seem to be more accepting of a route that involves dismissing the employee and offering him a new contract than they do an attempt to vary an existing contract without the dismissal in reliance on a potential clause that would potentially permit it. But advisors to employers need to be aware of the choice that has to be made, since, as this case indicates, quite significant consequences will flow from it. So, in summary, although the case was relatively fact-specific, it reiterates the message of cases before it. Unilateral variation clauses are difficult for an employer to rely upon. In order for them to be relied on successfully, they need to be very clear and unequivocal. Therefore, it remains prudent for employers to follow the more formal route of dismissal and re-engagement, unless there are good reasons for thinking a variation clause is either not going to be challenged or is sufficiently robust. So that's the case of Hart and St Mary's School, Colchester Limited. I would just mention, and I forgot to mention this in the last podcast, we are now putting the podcasts up on YouTube, and links and so on will appear on the YouTube version of this podcast. So if you're looking to catch up with cases, either follow me on Twitter, as I've mentioned before, or log into this on YouTube, pick up the podcast that way, because the links appear on the screen during the podcast. So that's the case of Hart and St Mary's. Next case is Williams and Leeds United Football Club. Well, this is a High Court decision which considers an employee's repudiatory conduct and subsequent dismissal due to a breach of the implied term of mutual trust and confidence. As a quick summary, every employment contract contains an implied obligation between employer and employee that neither will act in such a way as to undermine the employment relationship without good cause. Although both parties are subject to this duty, it is relatively uncommon for an employer to allege that the employee has acted in breach of this implied duty. However, in this case, it was the employer claiming the employee had committed an act that amounted to a breach of these implied duties. And this breach was sufficiently serious to amount to a repudiatory breach of contract, entitling the employer to dismiss the employee without notice. The background facts to this case are that Mr. Williams, the claimant, was employed by Leeds United Football Club as a technical director in August 2006 on terms and conditions that were agreed orally. No written contract or particulars of employment were drawn up between the parties. The oral terms set out that he was entitled to be paid a salary of £200,000 with 12 months' notice. So in July 2013, 23rd July 2013, he was given notice by reason of redundancy. Had circumstances not changed, of course, then he would have been entitled to his salary of 12 months and certain other benefits payable during the notice period. However, 1 week later, 30th July 2013, the claimant's contract was terminated without notice for gross misconduct. The claimant argued that this dismissal was wrongful, and he remained entitled to the balance of his 12-month salary and contractual benefits. That's what the case was about. Unknown to the claimant, the club had begun investigating his emails and expenses, looking for a possible way to dismiss him and all the other individuals who would be made redundant at the same time without paying notice. The High Court concluded the club had already decided by mid-June 2013, i.e. a month before they even spoke to the employee about the possibility of redundancy, that they were going to investigate the senior managers at the club to see if evidence could be discovered to justify dismissing them on grounds of gross misconduct. This was evidenced by a number of emails between forensic investigators and employees at the club. As such, before the claimant was even made redundant, the club was actively seeking to find evidence which they could use to justify his dismissal on the grounds of misconduct, without having any reason to believe that such evidence existed. As a result of these investigations, shortly after giving the claimant notice in July 2013, the forensic investigators discovered an email sent from the claimant's leedsunited.com address in March 2008, i.e. more than 5 years earlier, to a friend outside the club that contained a number of pornographic images. Once the managers of the club saw the email, the claimant was sent a letter setting out the disciplinary allegations against him. He was then dismissed without notice. Several months after the dismissal, the club discovered the claimant had also forwarded this email and the pornographic images to a junior female employee at the club and a friend at another football club. And so these emails were also sent 5 years before the claimant's dismissal. Club argued the conduct taken as a whole amounted to gross misconduct, entitling it to dismiss the claimant summarily over 5 years after the event. Club also contended that insofar as they had discovered some of the acts of misconduct after the dismissal, they were still entitled to rely upon those acts to justify the summary dismissal, and they did this relying on the well-known principles established in the case of Boston and deep-sea fishing, which in essence allows an employer who discovers repudiatory conduct by the employee after the employer has dismissed to rely on that subsequently discovered misconduct when it comes to defending the breach of contract claim. As you know, of course, in unfair dismissal claims it doesn't work like that. You're stuck with the knowledge you had at the time, and subsequently discovered misconduct would only be relevant to compensation. But the cases involving breach of contract is different, which is why it's important to bear in mind with what we're about to say that the case relates to a breach of contract case. So the claimant contended that although he was subject to the implied duty of mutual trust and confidence, the forwarding of the 3 emails did not constitute a sufficiently serious breach of these implied terms so as to justify summary dismissal. High Court disagreed, dismissing his wrongful dismissal claim. High Court considered the behaviour to constitute gross misconduct for a number of reasons, particularly due to the nature of the images sent, which the claimant admitted were obscene, the senior position the claimant occupied at the club, and it would have been enough had he only forwarded these images to the junior female employee. I find the decision an interesting one for a number of reasons. Firstly, because of the passage of time between the alleged offensive emails being sent and then being discovered, including that his conduct justified summary dismissal, the High Court wasn't troubled by this. Perhaps if it had been an unfair dismissal claim, we'd have seen the court come to a different decision, as the emails were sent over 5 years beforehand, and no similar emails had been sent before or after. So it might be rather harder to argue that the claimant's dismissal was fair. However, as this was a breach of contract claim, the courts decided the repudiatory behaviour could be relied upon by the club, regardless of when it was discovered, how long it was discovered after the original incident. As the conduct was considered to breach the implied terms of trust and confidence, it didn't matter when it had happened. The fact that there had been no negative consequences for the club as a result of the claimant's actions didn't excuse them. The claimant also argued that he'd continued to work for the club for a further 5.5 years after he'd forwarded those emails, and so the discovery of the emails themselves shouldn't be enough to destroy the relationship of mutual trust and confidence, and the relationship would have been sufficiently robust to survive. But the High Court decided this was irrelevant. The important question here was whether, when viewed objectively, the nature of the conduct complained of was such that the club would have been entitled to dismiss the claimant when they discovered it. The High Court concluded that the conduct amounted to a sufficiently serious breach of the implied terms of mutual trust and confidence, and consequently the club would have been entitled to dismiss the claimant without notice upon its discovery of the emails. The fact that the club had decided to make the claimant redundant, and then actively set out to look for evidence of wrongdoing to justify dismissal without notice, well, that was considered irrelevant by the High Court. The claimant argued that in deciding not to pay any further salary under his contract, before his employment was terminated, the club had committed an anticipatory breach of contract, which meant that they couldn't then rely on his subsequently discovered misconduct. The court concluded that under the basic rules of contract law, however, an employer is entitled to rely upon conduct amounting to a breach of contract by the individual to resist a claim for damages for wrongful dismissal, irrespective of the employer's motives or reasons and when the conduct was discovered by the employer. And this approach aligned with the case of Glencore, because in Glencore the High Court had concluded that the employer was not prevented from relying on a breach as justifying summary dismissal just because it had itself already given notice to terminate the contract or had decided to breach its contractual obligations, or even if, as was the case in the Leeds case, the employer was simply looking for a cynical reason to justify summary dismissal for its own financial reasons. Now, obviously, if the club had known about the email before the dismissal and had done nothing, the outcome here would have been very different. The High Court made a finding of fact that none of the club's senior employees who'd been involved in the decision to give the claimant notice of his termination in 2013 knew, at the time notice was given, about the sending of those pornographic emails in 2008. The High Court considered that had the club known of these emails previously, it would have sought to make use of them, given it was actively seeking to find a reason for dismissing the claimant, and I suspect there's something in that. As unsavoury as it seems, this case seems to demonstrate that employers who are facing an extended notice pay claim have an escape route. I'm sure this is one of those cases that will cause European employment lawyers to shake their head in wonder at the standards required by English employment law. The uncontroversial facts of an individual working for an employer who'd otherwise been a blameless employee sent one set of images to 3 individuals more than 5 years before the investigation. None of the individuals complained. There was no adverse press interest. The club's internet and email policy, which did make reference to the fact that sending obscene emails could be gross misconduct, was never provided to the individual. The club was entirely opportunistic in its approach. Notwithstanding this, the judge said that simply sending the email that the claimant admitted was obscene to a junior female employee would have justified the gross misconduct charge. I'm sure that if the email had been sent a month or 2 before the notice of dismissal was sent and the junior female employee had complained, the gross misconduct decision would have been an entirely foregone conclusion. Of course, sending emails which are obscene through the company's email system is potentially gross misconduct. It seems to me that we're expecting quite high standards for employees when merely sending one email in an otherwise untarnished employment career without evidence of any adverse reaction or adverse consequences for the employer itself constitutes gross misconduct. Well, that's quite tough. But this is, because I come back to it, it's a breach of contract case. We're less worried about issues of fairness and reasonableness, and we're more, is it repudiatory breach or not? The court was invited to decide that where the employer was opportunistically trying to exploit the finding of the email, it couldn't retrospectively rely on the gross misconduct which it had discovered to defend the breach of contract claim. But it declined to change what was up until now certainly settled law. I wonder whether there might be some scope to argue in a future case that a general trawling of an employee's email accounts to see if there is material that might be used. Well, I wonder if that could be viewed either as a breach of human rights or as inappropriate data processing, which might in turn allow the court to exclude the relevant evidence. Lots of ifs and ands in there. It doesn't appear to form part of this case, but in the circumstances where the individual has not been sent the email policy, as here, I wonder whether there might have been an expectation of privacy, or that an expectation of privacy might have arisen a certain number of years after the events, after the sending of the email, and so that the older emails might have been viewed as private. Maybe this will be something that will be picked up in another case. So overall, what does this mean for employers? Well, it sets the bar relatively low for employers to decide they're going to go back through email traffic, expenses, etc., in the hope of turning up some misconduct. Employees who are claiming damages for breach of contract are going to have to be counselled that, by itself, the passage of time, is not going to get them off the hook if they've done something untoward in the past. I do wonder if the claimant in this case had managed to persuade the female colleague to give evidence that she'd not been offended in any way, and she viewed this as banter or something similar, whether that might have altered the balance of things here. But that aside, it does seem that the court is setting pretty high standards for employees and allowing employers to benefit if they can turn up a single act of gross misconduct, a single email with obscene images, etc. on it. So that's Williams and Leeds United Football Club. Final case, Insley and Accent Catering. I'm going to deal with this very briefly. It's an Employment Tribunal decision, and I'm mentioning it because it's a follow-up to a discussion we've had about e-cigarettes in previous episodes. For those of you who are interested, we wrote an update some months back which featured on our LinkedIn group for in-house advisors and HR professionals on e-cigarettes and the use of employers' policies towards them. This case looks at a constructive dismissal claim made by a school catering assistant who resigned after being invited to a disciplinary hearing to consider allegations that she'd been smoking an e-cigarette on school premises and in front of students. As with the previous case of Williams, the case was a constructive dismissal case. It dealt with a breach of the implied duty of mutual trust and confidence. But in this case, it was Mrs. Insley, the employee, claiming her employer had committed an act that amounted to a breach of the implied duties by treating the complaint against her as a potential gross misconduct. Obviously, in the last case, it was the employer arguing that the employee had breached the duty of mutual trust and confidence. The brief facts are that the head teacher of the school spotted the individual having an e-cigarette on school premises. Following an initial meeting, she was suspended pending further investigations into the allegations. In the letter confirming her suspension, she was told that she was bringing the company, the catering company, into disrepute while smoking an e-cigarette on school premises in full view of the students. Head teacher provided a written statement in which he confirmed what he'd seen. At the investigatory meeting, Mrs. Insley asked if the catering company, her employer, had an e-cigarette policy, and she was told it did not, just a smoking policy. Following the meeting, she was invited to a disciplinary meeting to discuss the allegations, which were identified in the disciplinary invitation letter as potentially amounting to gross misconduct. And she was advised that a potential outcome could be summary dismissal. At the outset of the disciplinary meeting, she presented a resignation letter and she refused to answer any further questions. One of the complaints was that the catering company had failed to advise her of the rules and procedures she had contravened. However, the tribunal concluded that Mrs. Insley had been informed that the conduct of concern was the smoking of an e-cigarette, and the reason for not informing her of the breach of any specific rule was there was no such rule, save for the no-smoking policy, which did not expressly prohibit the use of e-cigarettes. Another point she raised in a resignation letter was the elevating of the complaint against her to be one of potential gross misconduct. She clearly felt that was overreacting. On this, the tribunal concluded that while smoking on school premises was potentially gross misconduct, this would have been for the disciplinary officer to decide on the facts and to determine whether it warranted dismissal. Alternatively, had she been dismissed, she could have claimed unfair dismissal, which would then have been for the tribunal to consider. However, this case hadn't reached either of those stages. What is interesting in this case, though, is that the tribunal did make it clear in its conclusions that had she not resigned, but in due course had she been dismissed, the dismissal might have been unfair, given the lack of express reference to e-cigarettes in the company's no-smoking policy. However, she'd not resigned, but she'd resigned and not been dismissed, and as such, the tribunal concluded that she'd not been justified in resigning because the catering company had not behaved in a way that undermined mutual trust and confidence. Well, the case acts as a useful reminder to all employers of the need to update their no-smoking policies to include the use of e-cigarettes, which, as we can see from this case, it doesn't automatically follow that a no-smoking policy will also catch e-cigarettes. So if an employer wants to ban e-cigarettes, no-smoking policies must be adapted to cover e-cigarettes as well. Similarly, updating the disciplinary policy for failure to comply with the no e-cigarettes policy. ACAS, I'd say, has produced some good guidance on the subject, and the guidance stresses the need for employers to amend smoking policies and to set out in disciplinary proceedings the consequences for employees. Given the increase in the number of e-cigarette smokers out there these days, it would be prudent for employers to address this in their no-smoking policies. And if they intend the use of e-cigarettes to be viewed as gross misconduct, where they're being used inappropriately, this would need to be set out expressly. On a personal note, I find the debate around e-cigarettes a really interesting one. As an ex-smoker myself, many years ago, I always took the view that I'd never be anti-smoking because there's nothing tackier than an ex-smoker who's violently anti-smoking. However, it's clearly, of course, in compliance with the law to ensure that non-smokers don't have to put up with cigarette smoke. However, on the basis of the medical evidence at the moment, there does seem to be a consensus that e-cigarettes are generally viewed as safer than actual cigarettes. And on that basis, I'm not sure what the employer's basis for banning e-cigarettes necessarily is. If e-cigarettes are correctly viewed as significantly less harmful than tobacco smoke from ordinary cigarettes, is it really so out of order to permit employees to have e-cigarettes in the office, I wonder? Is it really any different from banning an employee burning a scented candle in the office or eating smelly food at lunchtime? Maybe slightly facile examples, but the point still holds. Set against this, of course, there's the opinion from the British Medical Association, which encourages employers to ban e-cigarettes from the workplace and is quite critical of them. At the moment, I suspect employers are often justifying the ban where that's happening on the basis they're reflecting the majority will of the workforce, but it does seem to be a bit of an illiberal trend. Anyway, the clear message out of this case is that if you are to discipline employees for smoking e-cigarettes, your disciplinary policy needs to be clear and be properly communicated to individuals. In this case, the individual herself was found not to be a particularly credible witness, and so I'm sure that didn't help her case in the slightest. So that's the tribunal case, the Employment Tribunal case of Insley and Accent Catering. Now, I've slightly overshot on this podcast, but I am going to just very briefly mention the the other podcast series that I promised at the beginning of the podcast. I listen to lots of podcasts, and that's one of the reasons why I've ended up doing this podcast. And one of the best out there, and which I subscribe to, it comes out monthly or so, is called Hardcore History. And I can assure you it's nothing to do with the events that went on at Leeds United Football Club 5 years ago. Instead, it's a history podcast, and the presenter is a chap called Dan Carlin, Carlin. He talks a series of random subjects. At the moment, he's just finished doing one on the First World War, but he's done them on all sorts of different subjects. I remember there was a fantastic one on the Mongols. And he is a really, really interesting and engaging speaker, especially if you know relatively little about the subject. You really find yourself being caught up in the subject matter that he's discussing. So I can't recommend Hardcore History enough. It's freely available via iTunes. It's free, of course. And as I say, it comes out once a month, and it's well worth a listen. So, having said all of that, thank you very much for sticking with me to the end, and until we speak again in 2 weeks' time. Take care all. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.